With regards to, just to introduce Chris and Sam, Chris Butcher is the recently appointed CEO of Ambant Underwriting Services. Chris has 30 years' experience in the market and has held board positions at the likes of Coopergate, Navigators and the AXA Group. Ambant Underwriting Services specialise in providing platforms and services to MGAs, and I understand you have half a dozen within the group at the moment. Sam has over 30 years' experience, of which 25 years of that have been involved in the underwriting of intellectual property and intangible asset insurance. Sam is a founder member of Opus Underwriting Limited, which started business last year, and it's an agency exclusively underwriting intellectual property. So without any further ado, I'll pass you over to Chris.
Thanks, Jeff. Good afternoon, everybody. It gives me great pleasure to reiterate Jeff's words of welcome to the Lloyd's Library today. So I'm just going to set the scene for today's session with a very brief explanation of how we got where we are today, and then hand over to Sam so we understand a bit more about IP insurance in our changing world. But as Jeff mentioned, first of all, I just need to run through the CPD statement. So this is what we reflect on at the end. So we hope that this session will provide you and me with a high-level overview of the state of the IP market, and you'll come out having gleaned the various forms of intellectual property rights and how these rights can affect clients and what insurance solutions are available in the market. Sam runs Opus. It's a young, successful specialist MGA, which is part of Ambant's stable of 11 separate MGA businesses. Ambant Underwriting Services, again, as Jeff mentioned, is primarily an incubator or launch and host platform for new MGAs. It's completely independent, and that independence ensures that we have no conflicts of interest with either markets or distributors. Our business model is very, very simple, but it's quite different from most of our competitors. It's fee-for-service, and it's therefore quite an efficient method of allowing business owners to concentrate on what they're good at, and then by concentrating on that sole activity of getting them going, we're able to get an idea through business plan really in as little as 6 to 8 weeks. And it's a pretty simple process, but we have a project-managed approach to get from concept to actually being a live business in a very, very short time. Our key differentiation to the others that are incubators is that we don't expect to take a shareholding in the business. Hence, our clients maintain complete control. It is their business. It's quite different from the other incubator models where quite commonly 70 or 75% of the share equity is held by the party providing the platform, and that's not what we're doing. So how does it work? Well, to get the business going, we're a regulated business, so we lend our regulatory permissions to allow that business to trade, and then we provide compliance and other business services around that business for a transparent fee. The business model is quite cost effective because the clients only pay for the minutes that we spend working on their business. Our in-house team consists of accountants, technicians, credit controllers, lawyers, company sec, in fact, pretty much everything you need for a regulated insurance business. And this slide just gives some of the services that we'd commonly provide. Reassuringly, the vast majority of our new clients come by referral, both from our existing stable of clients and other people that have worked with Ambant in recent years. As an incubator, we expect that business to grow from a baby to a teenager and ultimately to leave home. This might take 2, 3, 5 years. But generally in that period, that business wants to take business back and outsource less of its activities than it would at the very beginning. Well, actually, what we're really seeing is that not happening. If we're efficient, we're providing good value for money, generally speaking, people are just saying, right, stay with you, which is good for us. So who finds our business model attractive? Well, in terms of our client mix, all of the clients, which, as I said, are all separate businesses, they're all specialists in their own product area, but they do have a completely different array of distribution methods. So we've got examples such as priority underwriting. They do onshore energy. They're based in the Lloyd's building, so it's a subscription business. We've got Solon Risk Services. Bill is here today, looking at European business and recycling products. Walsingham do commercial motor through specialist brokers in the UK, to someone like Corgi Home Plan, who have over 120,000 customers, retail business, a 50-strong call centre, very, very different. In between, we've got 8 other unique businesses, of which one very important one we're going to hear from today. So enough from me. It's time for us to learn some more about intellectual property insurance. So without further ado, I'll hand over to Sam to cover today's topic. Thanks.
Thank you, Chris. I hadn't realized that intellectual property is such an interesting subject, seeing you guys all in here. I've got some familiar faces that I'm seeing, but thank you all for coming. I'd like to thank Ambant for giving us sterling support in terms of back office. But intellectual property is all around us. In a lot of times, we don't even notice it. Let me just start by painting a picture of the IP insurance market from my perspective since the time I've been involved in it. I started my career in the UK in the legal expenses market in 1989. Then IP was part of a commercial legal expenses package. The cover essentially just covered the cost of suing somebody or defending an action. So it was purely a legal expenses policy. The limits of indemnities were very small. I think, Terry, if you remember, it was about 100,000. That was the most you could get. The underwriting of the class was very basic. I think all this, at the time, what we needed to do was just ask a client whether they had IP or not. And that was enough for us to give terms. In the mid-1990s, due to unexpected claims, the cover was removed from the commercial combined cover to stand alone. And this is what you tend to find now these days. Through a further understanding of the subject matter, IP as a standalone product has evolved into something that actually now provides ample cover for clients. And it will continue to evolve as we identify more pressing exposures that our clients face. From an underwriting front, there's a lot more sophistication now that's involved in the underwriting process. We now take time to try and understand what the client's portfolio is, what their position in the market is, who potentially could cause problems to the client. And from a claims perspective, we use tools that allow us to find, and in some cases assist clients to diffuse, mitigate, or preempt a problem that they have in the event of a claim. I will talk about the insurance solutions later on, towards the end of the session. But I think we need to note that the potential for this insurance is huge. For brokers who are in the audience, I think it's important that you raise this subject with your clients, because half the time brokers don't actually do that. And for the insurers, I think it's important to understand the subject matter so that at least we're equipped to underwrite the risks properly. And for some insurers who are maybe thinking of looking at it, I think Opus can provide you with help to risk manage these risks. I think as insurance people, we need to understand this subject a lot more. We've been very reactive to clients' demands. And in most cases, we should be proactive to make sure that we provide proper solutions. So without further ado, we are going to go through the agenda, explain who Opus are, what significance IP has to businesses. I'll talk about what is IP, and in that regard, I'll talk about copyrights, designs, trademarks, and patents, because you have so much confusion within the market sometimes. You get a broker saying, I've got a client who has patented their trademark. Okay? Those are two separate rights. We need to just understand what they mean. So to help with this, I'm going to look at claims examples that sort of puts it all into context. We'll then look at the insurance solutions, and at that point, you can ask me whatever questions you think are necessary. So who are we? I mean, for the scholars in the audience, I don't know, have you come across the name or the word opus at all. In Latin, it means creative work. I think you've heard Opus Dei. That means the work of God. So our word, our name, comes from that sort of notion that we are ensuring creative work. We also are an underwriting agent of Ambant, and they provide all our back office services. We represent quite a few syndicates in Lloyd's. And why do these people come to us? It's the experience we bring to the table. It's also access to analytical tools that we use in risk management. We then try and find out how significant IP is to a business. Interbrand, which is a sort of a consultancy firm, stated that companies that manage their intangible assets, their IP, effectively tend to outperform basic economic measures. You take a company like Google, for example. It's one of the largest companies in the world. What do they actually make? They're essentially a software house. So a large part of their assets are actually enshrined in intangible assets. In 2011, Google acquired Motorola, and that was really to buy the patents that Motorola had so that they can protect themselves within the Android ecosystem. WIPO, which is the World Intellectual Property Organization, estimates that within the Fortune 500 companies, people like Philips, Sony, etc., between 45 to 75% of their wealth comes from intellectual property rights. Let's bring it to a level that probably we understand. There are products in the market that provide cover for supply chains, and I doubt if most of them actually look at the intellectual property implications of that. The example you have here shows a client who probably gets raw materials or software from another party and then sells on their product to somebody else. I think as insurers, when you meet with clients, you need to understand where do their liabilities start and end. Because the act of selling on a product or a service, even though it doesn't belong to you, could be an infringing act in itself. So clients need to be aware of that, and as insurance people, we need to make sure that we provide them with the right tools from an insurance perspective to help them. What is intellectual property? It is any creative work with commercial value which can be trademark, marketed, patented, or copyrighted. It also covers other rights, like, for example, there's a list here, patent plant varieties and trade secrets. Let me look at these rights in more detail. Copyright is any creative original work in literature, art, or music, etc. The law grants the creator of the original work exclusive rights for its use or distribution. The right is a territorial right, so it only applies in the territory that you've created it, and laws may vary from country to country. However, copyright tends to expire between 50 and 100 years after the death of the author. What I've done here is I've shown you two cases that have happened in the last couple of years. The first one, the Da Vinci Code. Two British writers, I don't know if you're aware of this, they wrote the book called Holy Blood and Holy Trail. They brought an action against Dan Brown, who wrote the Da Vinci Code. The matter revolved around the idea that Jesus had a bloodline. The court decided that the idea in itself cannot be copyrighted. Had he copied a chapter, then maybe the decision would have been different. In the other example that I give, we all sing happy birthday songs. I don't know if any of you are aware that if you were to use or sing that song in a commercial basis, you had to pay royalties to Warner Chapel. Were you aware of that? Last month, the courts decided that actually the rights that Warner Chappell had was not so much in the lyrics or the melody, but to a specific piano arrangement for the song. Warner Chappell were getting $5 million of income every year from using this song. I move on. Design. They protect the visual appearance of a product. If registered, they give the owner the right to prevent others from using it for 25 years. If not registered, in the UK, you get automatic rights under what they call design rights, which applies to the shape and configuration of the object, and it lasts for about 15 years. I've shown you an example here of a case between Dyson and Vax. You can see, I think, that they're very similar. But in fact, the courts decided that Dyson didn't have a claim for this, so they lost the action. Dyson as a company tend to get involved in quite a lot of IP infringement actions. I'm not sure whether they've got insurance or not, but they are very protective of their IP. We move on to trademarks, and these are rights that distinguish a product, design or expression, so that you can identify it from others. The trademarks last for about 10 years. And again, it's a territorial right, so it only applies in the territory that you have it registered. You can have unregistered trademarks, but for that, if somebody has an unregistered trademark, in order for them to be able to sue, they have to prove prior use, and also the fact that this has caused confusion to the market and likely to cause loss to the client. But for the holders of trademarks, they can take legal action against anyone who's using their logo brand without permission, and this includes counterfeiters. For that, I've given you some recognizable brands that you probably are aware of. The one below that, I don't know if you can see that. That's a trainer with the same sort of logo, but the words at the bottom are dyads, causes confusion. You've got KFC there, company that's riding on the back of KFC with KLC. You've got another one, Nike. They've replaced the K with an R to make it Naya. These are problems that our clients would have. I mean, it can apply to insurance brokers as well. I mean, I don't know if any one of you have teenagers. I've got. But I read the other day, yesterday I think, that the TV series called Glee, do you know of it? There's the Glee Comedy Club in the UK. They have taken a high court action against Fox, who own the Glee series, to stop them from using the name Glee within the UK. So they may actually be forced to change the name of the show in order to show it in the UK. We move on to patents. So we've dealt with copyrights, designs, trademarks. Another right is patents. They tend to protect the technical effect of a product or process. Again, these are territorial rights and last on average 20 years. WIPO state that in 2013, there were 2.6 million patent applications just in the year, which was a 10% increase from 2012. So again, there's a lot of activity within the patent world. I show here two patents from Thomas Edison for a light and Graham Bell for the telephone. It is interesting that 100 years later, there's still development within these two areas of technology, lighting and telecommunications. Again, only the other day I read that there is a convergence of these two areas with the introduction of Li-Fi. Has anyone come across Li-Fi? it's another version of wireless communication. So instead of using radio frequency, they use infrared, which is, we can't see from the naked eye, but it comes from the light. The fact that light is super fast, it means your wireless connections would be very fast. The fact that light can't penetrate through walls, it actually means if you're at home, your neighbors can see what you're doing. So that's the way technology is moving. But it's not easy, the patent world. It can be very difficult, very complex. I mentioned that patents are territorial rights. So you could find a client with a patent, say, in the UK, that's slightly different to a similar patent that they may have in the US. The reason for that is that it may depend on prior art in the territory that they're applying, where the examiner says, you know what, I think you possibly may run into problems with this other patent that's there, so you might need to change it slightly. What you also have is one of the complications. For example, the US used to work on what they call first to invent basis. So you could have an inventor work in a garage for 2-3 years on their invention and then go to the patent office and say, I want to register my patent based on the work I did for the last 2 years. The right would go back to the time when they actually started working on it. The whole world tends to use first to file, so it's quite good that the US have moved on to that platform, which is actually quite easy because it means everyone starts off at the same date when you filed your patent. In the US, for example, they don't have designs, they've got utility patents. And in Europe, they've been talking for the last 40 years to see if they can have one standard patent, they call it a unitary patent, that applies to all member states. It's been 40 years in discussions. They're still working on the court system. The legal framework has not been agreed to yet. But the main courts will be established in London, Munich, and Paris. That makes it easy because you're harmonizing the laws, because each country seems to have its own way of looking at these things. But it also causes a problem to the SME market, for example. You can have a big company take action against a small company, let's assume they're successful, and injuncts the small company from selling the product. That means they actually cannot sell the product within the 25 member states, or however many they are. So that's one of the problems that you can have with this system. Before you had to sue in each territory and get a decision, but now these are some of the changes that are going on in the IP world. The language that is used sometimes in patents can be very difficult to understand. So what you have with a patent is you have the claims which define what the invention is, and I'll be hard-pressed to understand some of the language. So just as an example, how would you define this?
Well, breakfast.
Breakfast? But what is it? What is it? How could you explain it in language, English language? This is how it's explained. I also give you that wording. Could you tell me in simple language what you think it is? No idea? There we go. So it can border on the bizarre. I mean, we have a circulation transportation device. Effectively, that is a patent that's been applied for. And if granted, they could technically sue anyone who makes a will. Again, you move on. This is a granted patent in the US, swing. They could technically sue every playground for using swings without their permission. So, as a nutshell, it's very difficult within the patent world to just make decisions on this. The language can be very difficult, and clients in some cases don't actually know what their positioning is. what I have given you there is a list of the number of actions that have happened since between 2006 and 2012. And it actually shows that China, if you include number 8, Taiwan as well, there are 31,000 cases that have been brought within the courts of China. United States, which was always at the top, is now second. And look at where England is, right at the bottom. What I've also shown you here is the kind of awards that are given or granted to companies that are found to be infringing. And in this case, you find that within the biotech sector, which is not surprising, the average costs or damages issued are 21 million, followed closely by telecommunications, which is 19.7, and medical devices. This is actually not surprising. There's a correlationship between these figures and the number of claims that actually happen within the sectors. So from an exposure standpoint, these are the areas where you need to be careful of. What does this all cost? I mean, you're looking 1892, so almost 150 years ago. Lord Isha identified that or equated the getting involved in a patent suit as similar to losing one's entire life to influenza. And I think what he meant there was it's the impact of cost. So how much does it cost generally? If you were to bring an action all the way to the high courts in the UK, it'll probably cost you about £700,000. In Australia, again, on average, it's about 2 million Australian dollars. And in the US, it's about 3 million. But the US, you don't have boundaries there. It can be very expensive. I'll give you some examples of cases that you may know of. The Blackberry case. NTP was a small company. You could deem it a patent troll. These are companies that don't manufacture anything. They went to BlackBerry and said, we believe that this idea of getting emails on your mobile device infringes on our patent. BlackBerry decided to defend the action. That's how much they ended up paying these guys. I met the lawyer who represented NTP, and he was saying to me that they only wanted $5 million to go away and then target maybe Apple or whoever else was offering emails via your phone. The lawyer was saying his costs were $5 million, and BlackBerry Reams incurred $24 million of cost just defending this action. You all know about the ding-dong that goes on between Samsung and Apple. Look at the damages that were awarded against Samsung, $105 billion. This is just probably not to scare you, but to highlight that there are problems, and as insurers, we need to think about this. So what are the insurances or insurance solutions that are available? There are some liability policies that offer an extension to IP, cyber being one of those. You tend to find that they include certain covers. But I think for the brokers in the room, you need to be very careful how this is offered, because in some cases you find that they exclude patents or even designs, and clients may assume that they have full cover. What we do under our range of these products is to actually offer comprehensive cover. So infringement assertion insurance, as denoted by our symbol though, it's a cyber, it's someone pursuing potential infringers. This is often referred to as pursuit, enforcement, or offensive cover, and it applies to people who actually hold rights. It generally pays for legal fees incurred in pursuing a potential infringer. You can find extensions for this which affect the title of the right, so challenges to title, or invalidity actions regarding the ownership of the title, and also maybe sometimes breach of contractual obligations. The limit available in the market generally for this is about $3 million, or £3 million, and it can be available on a worldwide basis. So the second cover is infringement liability cover, and that's really a defense cover. So I mentioned before that the act of selling, manufacturing, producing could in itself render a client liable for IP infringement. So this kind of policy provides the client with the ability to defend, and in the event that they actually lose an action, the policy would pay for damages. There are extensions that you get, and for example, you have contractual obligations where a client may give an indemnity to their customer to say, if you get sued for selling on my product, then I will indemnify you for fees and expenses, or even damages that may arise from that. This is an area that we're finding a lot of interest from, because invariably now you tend to find that purchase orders, service delivery contracts will include these kind of indemnities. So we can provide solutions for this, and our insurances are now acting more like a facilitator for such transactions. Because in some cases you get clients who are being asked to put money into escrow, or they try and find an insurance solution. You also get product recall type coverage, where in the event that somebody is found to be infringing, they may be liable, or they may be asked to withdraw all the infringing products from the market. Again, insurances can wrap around and include such costs. Limits of indemnities can range to up to 100 million on this, and we've placed, I think the highest I've placed so far is 50 million. But for SMEs, it tends to be at a much lower rate. It's about 2.5 million. The third one, and the final one that I'm going to talk about, is revenue protection. This is a relatively new form of insurance which is now starting to take prominence. It applies where a client's IP rights are impaired, or for whatever reason they're found to be infringing third-party rights, and we then look at the financial loss that the client themselves have suffered. And the financial loss could be loss of profits. We've had situations where a client says, you know what, I need to be able to recover the research and development costs I've incurred in trying to get the business to a certain position, and then I'm stopped from doing that. We can also look at royalties that they would have got, assuming that they sell their products through licensees or people like that. We work very closely with the client to try and tailor-make that cover and identify what the financial loss is. I hope that's been food for thought. There's a lot to think about. There's a lot to take in. But let me say this, that I think as insurance people, we need to understand this class a bit more. It's all around us. It's every day. It's not going to go away. We need to bring the insurance into the mainstream, but we need to be careful how we underwrite the risk, because a little information can be dangerous. I hope you found it very useful, and if you have any questions, please ask away.
Sam, thank you very much for that. If you don't mind, I'm going to be quite selfish now and start the questions. In your opinion, what percentage of companies in the UK where this type of insurance could be applicable to them do actually buy this cover?
The cover would apply to any company that's trading, but surprisingly, you tend to find that because brokers don't mention it, we are reactive. It's usually where there's a contract in place that needs to be insured that the type of insurance is raised. So I'd probably say it's a very low percentage of companies that buy this.
Thank you. Other questions?
Following on really from, thank you. Well, question for Sam. Following from Jeff's comment there, in the context of Lloyd's, is there an IP risk code? Does it have its own risk code?
I mean, this is one of the things I would probably implore Lloyd's to do, because if you were to ask Lloyd's today and say how much IP insurance is written in Lloyd's, they'll be hard pressed to tell you.
Well, that's going to be my next question. You know, what the spend, IP spend in the world is, and how much that finds itself into Lloyd's.
The problem is IP insurance falls under cyber, it falls under miscellaneous PI, it falls under legal expenses, and I think it's high time that Lloyd's made the decision that they need to have a separate risk code for it.
Which risk codes do you use at the moment?
It could be E9, E8,
Okay.
depending on the syndicate and how they classify that risk.
Sure.
But there isn't one place where you can actually say this is how much is written in Lloyd's for IP exposures.
Okay, and following on from that as well, in the context of the MGAA while we're here today,
Yeah.
the distribution of your product, is it mainly through delegated authority, or is there some open market stuff? Thank you.
There are currently 2 markets or MGAs that are specifically looking at this, us being one of them. But now I think you're finding a difference. I mean, there are a few underwriting syndicates who are here who are actually writing this themselves directly to the market. Oh, yeah.
Hi Sam, very simple question from me, Reg Brown. It's a long time since I wrote this class of business, but can I ask you a question on your revenue protection insurance?
Yes.
And can I go back to the Happy Birthday case? What was their name? Warner Chappell had been milking the market for years, getting $5 million out of it, and the court has decided they weren't entitled to it. Would you indemnify them under your revenue protection insurance? For what?
Technically, yes. But what we would have done within the underwriting process is to look at what rights they actually have. So we'd spend time looking at those rights and seeing that if we're satisfied that actually we think from a legal right perspective they own them, then there's no reason why we can't offer them defense cover. And similarly, any loss of revenue that they get as a result of this. So in this particular case, they're going to be losing $5 million every year. We agree an indemnity period. We would have said, okay, if this happened, then we would repay you back whatever the figure is, the sum assured. But it is possible that we could do that.
And being an awkward bugger, I would ask them for all the back revenues I've been paying them all the years. Are they now legally obliged to pay it back?
I would imagine that would be the case. I'm not an IP lawyer, but I think the argument is that because they didn't have rights to the music anyway, people have been paying royalties on something that they actually don't own. I would put in a claim and say, you know what, I paid you because I thought you had the rights, but given that you don't have them, I want my money back.
Okay, thank you, Reg.
Sam.
Terry.
Hi, Sam. Sam, I first got involved in this class about 20-odd years ago, if you recall, and was told at the time, or the perception at the time, was that this class would be the next D&O in terms of volume, premium in the marketplace. And yet here we are 20 years later. My perception is still, whilst it's grown to some degree, it's still not established itself. I just like to know what your views as why you think it hasn't.
Hopefully one of these sessions is to try and say to the insurance fraternity that, you know, it's something that we need to get to grips with. It's an exposure that clients face, and we have to find solutions for them. And I think naturally what people do is, if I don't understand the class or the subject matter, I won't talk about it. So by educating people, you break those barriers down, because ideally what you should have is a broker going to see their client every year and then saying, okay, let's talk about public liability insurance, let's talk about employers' liability insurance. Oh, how do you run your business? What exposures do you have? And can we have those covered? And I think once people get to that position, we'll see a lot more of this coming through. I did say that before, as you know, Terry, we used to get, there was a lot of selection against underwriters. It was, 1 in 10 or 9 in 10 would probably make a claim because they know the potential dangers that they have. Because now you have a lot of contractual obligations being placed to sellers. For example, if I were to sell into Homebase, and whatever my glass Homebase would say to me, before we put that on the shelf, we need you to indemnify us should we be sued for selling that. So I then have to give an indemnity to Homebase, but if I'm a man of no means, how do I do that? Either I go to insurance and see if I can find a solution there. So that's where we're getting a lot more inquiries from.
Hi there, Sam. Paul Adams from Profile with Solutions. I was quite interested in one of the slides that Germany and France, the litigation numbers are like a multiple of what they are in the UK. Is that a more established market, or are the numbers growing in the UK rapidly to sort of catch up with that? Or
what I would attribute the difference to is Germany they've got a different court system. At the moment, if I have a patent litigation action, I go to 2 courts. One is to look at the validity of my patent. So should I have had this patent in the first place? And then the second issue, or the second court, would look at whether there's actually been an infringement at all. So you can have a mismatch where I get one court saying, yes, you've infringed my patent as it's written, and then another court says, actually, you know what, Sam, that patent should never have been given to you because it's obvious. It should never have been something that you have a monopoly on. So by that very nature, you've got 2 courts that are dealing with one action. In the UK, it all goes into the same court, and they look at all those factors.
sorry, just on the UK, is there an increasing trend of people actually taking people to court for potential infringements?
I mean, people do take people to court. What you tend to find with IP is probably 95% or even more tend to get settled before they go all the way to the courts. IP tends to be a very emotive issue. If you're an inventor, you won't be surprised that they'll say, I want my day in court. But at some point, because of the litigation and the costs, the commercial reasoning behind it, sometimes they'll settle.
Hi, Sam. Just asking about the profile of the clients that you would expect to be insuring in this market, because although all companies are going to have the issues of IP, where's the level of affordability, and do you aim this at the mid-market sector where maybe they're not going to be defending their own actions, or what size of companies are you expecting the market to be looking at?
Right. When you look at the bigger companies, they tend to have a big IP department and possibly can afford to take the action themselves. So the Microsofts, the Googles of the world, they have teams of people, and that's all they do every day. I met a guy from actually Google, and he was saying that they get sued every week. They get a suit every week, and they've just got a team of people that deal with that. What we aim with this product, or this insurance, is to go to the SME sector, because if they do get a claim, it can actually wipe them off. So this would be a balance sheet protection for an SME. That's ideally where we want to be. The limits are low as well, so if you get a total loss, you probably will be able to pay for it. That's where we tend to. That's the sweet spot for us.
Okay. If that's all the questions, thank you very much indeed. Firstly, I'd like to thank Ambient for sponsoring today and for lunch. Very kind, thank you. Secondly, we have a prize draw. Is that correct?
We do.
We have a prize draw. Finally, just to really say thank you very much indeed to both Chris and Sam. So if we can just thank them in the usual way. Thank you very much indeed.